Now, leading our bulletin, former President Jacob Zuma must go back to prison. The High Court in Pretoria has set aside his medical parole. It's declared former Correctional Services Commissioner Fraser's move unlawful. The department's been ordered to take him back into custody so he can resume his 15-month sentence. His time spent on parole will not be counted as part of his time served. Correctional Services says it's studying the judgment and will make an announcement soon. Now, for more reaction on this, I'm joined by legal expert Ulrich Roux. Ulrich, good morning. Thank you very much for your time. So, we've just heard now that the courts have decided that former President Jacob Zuma must in fact go back to prison. Your initial take on this?
Hi, good morning. Thank you for having me. Yes, certainly when the decision was made that he is a person who qualifies to be released on medical parole, it was met with a substantial amount of scrutiny and dissatisfaction. And the reason for that was because of the fact that the then Commissioner of Correctional Services, Mr. Fraser, actually went over the heads of the Medical Parole Board, set aside their decision not to grant Jacob Zuma medical parole, and then used his own discretion saying that this is a person who does qualify for medical parole. And in my opinion, the right decision has been made today. The court confirming today that the only statutory body that can determine whether a person qualifies for medical parole or not is the Medical Parole Review Board. And that the then Commissioner of Correctional Services, Mr. Fraser, did not make a rational decision in finding that Jacob Zuma should be released on medical parole, despite the fact that there was numerous medical reports saying that he is a person who can adequately go about his daily activities should he be imprisoned, and that he accordingly does not fall within the categories to be released on medical parole. So in my opinion, the correct decision was made today.
And then the argument, Ulrich, on the mootness of it. It's been dismissed. What did you make, though, initially of that matter, where now we had Zuma's legal counsel maintaining that this matter was now academic since he was now eligible for normal parole? What did you make of that argument initially?
I don't think there's any basis or merit in that argument. The fact of the matter is that he was sentenced to 15 months imprisonment for being in contempt of a constitutional court order. Only upon applying to be released on parole would such an application be considered by the parole board. So now to say that he would have been released on parole already is ludicrous, to say the least, because his parole application has not even been reviewed properly. And the parole board needs to take into consideration numerous factors before deciding whether he should be released on parole or not. So I don't think there's any merit in that argument by his legal team that this was a moot application. And if one looks at the judgment handed down by the Pretoria High Court, it is an agreement. It says that there's absolutely no legal grounds to say that he would automatically have qualified as a person to be released on parole. So I think what we can expect now to happen, in true Jacob Zuma style, he will most likely try to appeal this decision. He will have to approach either the full bench of the High Court or approach the Supreme Court of Appeal in Bloemfontein. Once he lodges his application for leave to appeal, he will also then have to lodge an application to hold his imprisonment in abeyance pending the outcome of the appeal. He would be granted now, should he elect not to appeal this in the very unlikely event of that taking place, then he would be required to hand himself over to the Department of Correctional Services within a reasonable time. So they would most likely send him a letter and say, in accordance with the High Court order made today, you have until close of business, either on Friday or for reasonableness on Monday, in order to hand yourself over and to serve the remainder of your sentence of imprisonment of 15 months.
You know, just to take you back to Arthur Fraser and his reasoning, I had actually watched one particular interview where we listened to the commissioner state or take us through delegations that in this instance he had actually taken it upon himself to make the decision because it was a decision that ordinarily could have been made by the prison head. But he decided that in this instance it was a very serious matter and he now withdrew that delegation. But he also went on to paint a picture somehow diminishing the advice of a medical parole board to some sort of an advisory panel where they can recommend, but then he would be the one with the final say. Do you perhaps remember that type of argument that he made that sought to diminish the significance of advice given to you by the medical parole?
Yes, I remember it clearly, and I think that is the importance of today's judgment as well. The court reiterated the fact that the only statutory body who is able to make a decision whether to release a person on medical parole or not is the Medical Parole Review Board. That is the only body. And the fact that Arthur Fraser, in his capacity as the then Commissioner of Correctional Services, overstepped and set aside the decision by the Medical Parole Review Board is seen as being an unconstitutional decision, and that he had no reasonableness or grounds to do that, that it was not a sound decision made by him. And that is a very important order made by the court today, because it would prevent any future decisions such as this from taking place. The Medical Parole Review Board is an objective and unbiased board made up of selected experts in their field, and they make an adjudication on evidence submitted to them whether a person should be released on medical parole or not. Quite frankly, the Commissioner of Correctional Services, Mr. Arthur Fraser, does not possess over those expertise, and he cannot be seen as an expert in the medical field, and accordingly, his decision to set aside the recommendation of the Medical Parole Review Board is seen to be unlawful and unconstitutional.
Now, if we had to play devil's advocate here and talk about the form of recourse that the former president has in this matter, could it be argued by his legal counsel now going forward, if they were to appeal, to state that if the courts have found that the decision by the commissioner was actually unlawful, he should not be disadvantaged in that respect because he has in fact become eligible for parole, that there should be some sort of sanction that is directed at the commissioner but not necessarily him in this instance? Would you think such an argument would hold in court?
Well, the fact of the matter is that the commissioner's decision obviously has a direct impact on Mr. Zuma. So I don't think there would be much merit in that argument. The fact of the matter is that the application launched by, let's just remember there were two urgent applications launched. The first was by the Democratic Alliance on 10 September this year, and then the second a few days later by the Helen Suzman Foundation and AfriForum. And the court decided to combine the two applications because in essence they related to the same facts. But importantly, the Helen Suzman Foundation requested that the court make an order that the period that Jacob Zuma spent on medical parole, that he was not incarcerated, should be disregarded by the court. So in other words, the period of imprisonment that he served from when he handed himself over in July until being released in the first week of September is the only period that will count towards his sentence of 15 months of imprisonment. When he hands himself over now again, then only will his period of imprisonment start to count again. And quite frankly, he then does not qualify as a person to be released on parole as yet. He has not served sufficient time of his sentence as yet. And as I've said before, if they say that he would automatically qualify for parole, then they must still go through that process of applying for him to be released on parole. It is not just an automatic decision that is made. It is an application that is brought to the parole board, and they then consider the application as well as all the surrounding circumstances. They take into account the impact that such a decision would have on society. They take into account the severity of the offence of Mr. Zuma in this instance, and they regard the fact of whether he shows remorse for his contempt of court and whether he has been rehabilitated by serving a certain period of his sentence of imprisonment. So that entire process must still unfold. If his legal team says that, well, he's now being prejudiced as a result of a decision made by the Commissioner of Correctional Services, then so be it. He was also a respondent in these matters, and accordingly, yes, he obviously benefited from the decision made by the Commissioner, and accordingly, you know, he falls by and is bound by the court order handed down today.